Hello, this is Matt on the Moon Lambeau channel, and the SEC is at it again, attacking Ripple. Here's a headline from Crypto Newsflash. SEC attacks Ripple's key defenses, calling them, quote, legally improper. Now, potentially this is going to be a problem because this idea of due process, of fair notice, is a notable portion of Ripple's defense here. And if the SEC gets their way, they're not even going to be able to make this case in court. They won't be able to bring it up. So this actually matters tremendously. Now, I will tell you, even at the outset, because I've gotten opinions from a ton of different lawyers on this, I'm going to be citing three specifically within this video. They all think that Ripple's claims of a lack of fair notice, which I'll get into if you don't recall what this is about or haven't heard yet, don't worry, I'll catch you up to speed. But there's three lawyers I'll cite in this video that say, no, this claim that Ripple's putting out there, it has teeth. And if anything, the fact that the SEC is going after this portion of the defense specifically before even getting to trial speaks to a degree that the SEC likely is aware that it's a tremendous problem. But there's a lot on the line here, because if the SEC is victorious and having this opportunity for Ripple removed, not going to be so hot. Now, I do want to be clear that I don't have a legal background of any kind, so I'm certainly not offering legal advice. I also don't have a financial background of any kind. I am not offering financial advice, and you should not buy or sell anything because of anything that I say. All right, I'm just an enthusiast. I'm no more special than you. I just like to talk about crypto and XRP and Ripple-related topics and make YouTube videos purely as a very fun hobby. That is all that it is. In the interest of full transparency, I annoyingly repeat that in every single video, but it's the right thing to do. There's always new people subscribing to the channel, and so I gotta do it or I wouldn't feel right. So to get everybody caught up to speed here, I'm not going to read this whole thing. I actually went through this very thoroughly in previous videos, so I'm just going to make sure that I've covered it sufficiently to get people caught up. This is Ripple's answer to the SEC's first amended complaint, and they threw in this. There you go. Fourth defense, lack of due process and fair notice. Take a look at this. I'm just going to cover a few little bits of it just to make sure we're talking. Because this is what the SEC, just to be clear, this is what the SEC doesn't want Ripple to be able to argue in court. And they're asking a judge to strike this out, to make it so that Ripple cannot argue this in court, assuming we get there if there's no settlement anyway. And this matters. So here's what Ripple wrote, though. Ripple did not have, and plaintiff failed to provide, fair notice that its conduct was in violation of law, in contravention of Ripple's due process rights. Due process requires that laws give a person of ordinary intelligence a reasonable opportunity to know what is prohibited. Here, due to the lack of clarity and fair notice regarding defendants' obligations under the law, in addition to the lack of clarity and fair notice regarding plaintiffs' interpretation of the law, Ripple lacked fair notice that its conduct was prohibited. And so, I found, so far to this point, seriously, I've only found one lawyer that thinks that that this is not a good legal defense. This idea of talking about due process and fair notice. One lawyer, his name is Jake Chervinsky. I've highlighted his opinions on the channel. I'm not going to be doing it in this video. He's still the only one I can find, outside of the SEC, of course. Other than that, multiple lawyers think that this is a serious argument that really has teeth. And clearly Ripple's legal defense team believes the same. And don't forget that they're comprised of former SEC employees, including an SEC director and an SEC chair, who both lawyers, who say, no, this is an excellent argument, and they made sure to put it in this first amended response, or the answer to the SEC's first amended response, rather. And so they continue. Check this out. Prior to the SEC's complaint, countless market participants for years transacted in XRP, believing it was not an investment contract. XRP was listed on over 200 exchanges. Billions of dollars in XRP were bought and sold each month. Numerous market makers engaged in daily XRP transactions. Ripple's on-demand liquidity product was used by many customers, and XRP was used in third-party products, many of which were developed independently of Ripple. In short, there was no fair notice to the market that transactions in XRP violated the law, or that the SEC would later claim XRP itself to be and to be an investment contract. And they also do go to talk about how the U.S. Department of Justice and FinCEN did declare that XRP was a, quote, convertible virtual currency. And so they made sure so I think that's a strong argument as well as part of all of this. And so since I don't have a legal background, I personally couldn't tell you, what's a good legal argument and what isn't. I can just tell you that the attorneys that publicly speak about this, almost 100% of them think that this is an excellent argument. And so even without me knowing whether or not, with my, from my own perspective, since I don't have a background in this, even though I couldn't say for sure with my own genuine original opinion whether or not this is a good legal argument, just thinking through it from a logical perspective, the SEC is bonkers off the walls. To not take action for 8 years and then say, no, we did not violate your due process here. We provided fair notice, or certainly at a minimum, the claim that fair notice was not provided is not valid. It's not logically sound as far as whether or not it's a good legal defense. It doesn't sound like the SEC is on the right side of this. It just doesn't. And so I want to share with you part of what they wrote, because this is the document here, which was filed just yesterday from United Securities and Exchange Commission to the Honorable Judge Annalisa Torres, who's presiding over this whole train wreck here. And I just want to cover part of this. This is what the SEC wrote. In its amended answer, Ripple states that due process requires that laws give a person of ordinary intelligence a reasonable opportunity to know what is prohibited. And then Ripple alleges that it lacked this notice because of the supposed lack of clarity and fair notice concerning defendants' obligations under the law, and because of the supposed lack of clarity and fair notice regarding the SEC's interpretation of the law. Ripple also alleges that this claimed lack of notice was exacerbated when Ripple entered into a settlement with the U.S. Department of Justice that described XRP as a convertible virtual currency, and for years after was not sued by the SEC. The SEC's then Director of Corporation Finance made remarks about his view of a different digital asset, and the SEC staff met with a digital asset trading platform and did not state that the SEC considered XRP to be a security. And so that's a huge part of where all this stems from, just to be clear. It came to light fairly recently that there was at least one cryptocurrency exchange and perhaps other big players in the industry that approached the SEC. One of them said, hey, we're trading XRP. Is this, I'm paraphrasing here, but is this a problem? Is this a legal no-no? And the SEC didn't say, no, don't do this, or anything to that effect, which is really part of what got all of this rolling here. And so here's what the SEC states, though, about all of these points that Ripple brought up. This is the quote now from the SEC. None of these facts, even if proven, would set forth a legally valid defense to the SEC's Section 5 claim against Ripple. So I just gotta wonder, do they believe what they're writing there? Because I'll tell you what, Ripple's legal team, they're not idiots. If they didn't think this had some serious teeth, they wouldn't have put this. Oh my God. First of all, they wouldn't have put it in at all, but they put in a rather lengthy explanation, which again, I didn't go through the whole thing for the sake of this video. I previously have on this channel, but holy hell. And then to see all these other analysts just go through and be like, no, this actually matters, and there's precedent for this. I just think that, these SEC lawyers, they got to be like Jay Clayton, like they're just a bunch of asshats. And it's not about what they actually believe. It's that they're doing their job. And I tell you what, I wouldn't want to be in their position. They probably feel forced at this point. I would not want to make these arguments. I would never want to argue something that I don't believe in. It's so illogical that it's hard for me to believe that they're being genuine when they're covering all of this here. And so take a look at this. Here's an attorney, James Phelan. I don't know for sure if I'm pronouncing his last name right. My apologies if not, but he just shared the 4-page document, of which I cited a couple snippets right there. It's what the SEC responded to, sent to the judge saying, hey, let's go ahead and deny these valid Ripple claims, right? And then attorney Jeremy Hogan responded to that and wrote, you attack first what you are most scared of, right? Which I thought was an interesting approach. If they're going after this and they're trying to make sure it doesn't even get to trial, what if he's onto something there? What if this is one of the most scary aspects, if you're the SEC, of what's going on here? What if it really does have teeth? And the SEC, despite their claim that there is no, reasonable legal application of this, what if they're like, oh yeah, it is. That's why we're going. That's why I think it's hard for me to believe that a lot of what the SEC is putting forth here in these legal documents, it's hard for me to believe that they're being genuine on all. I'm not saying that they're not on all of it, but for the stuff that matters most certainly to XRP holders, at least as far as whether or not XRP is a security today, to me, their position is completely nonsensical and illogical. And so here's some more from attorney Jeremy Hogan. 3 quick thoughts on this, and this is in his initial thoughts based on this 4-page document from the SEC. 3 quick thoughts on this. 1, the SEC wants to remove Ripple's fair notice defense because they are worried about it. Number 2, it would be a blow to Ripple if it is removed. And number 3, the SEC wants it done quick because there are facts they don't want to come out in discovery. And so what's he talking about there? Well, I think what he's talking about is a lot of the stuff that could potentially come out in discovery has to do with exactly what I cited just a minute or two ago. That there's at least one major entity, a United States-based cryptocurrency exchange, and I've gotten the hint that there actually may be some others, but a major U.S. exchange that was allowing the trading of XRP. And so who knows what else would come out during the discovery process. Ripple will only be armed with more and more information, and so of course the SEC wants this thrown out, whether or not they think it's ethically the right thing to do. I don't think that they're behaving based on ethics here. I mean, that's throw that concept out the window and put it in the wood chipper. I don't think that's at all what's happening here. And so then there was, I think, here we go. So then there was, I think that's where I would have jumped to. Let me just double check. Yeah. So now here's attorney John Deaton, who wrote the following in response to this. The SEC files the most overbroad complaint, claiming from the beginning of time until today, Ripple has had one continuous offering of unregistered securities in XRP. Ripple defends itself accordingly, and now the SEC runs crying to the judge to narrow Ripple's defense and strike down its due process fair notice arguments. Exactly, because the SEC is full of just a bunch of baby back biatches, And then he wrote, attorney Jeremy Hogan is 100, with the little 100 emoji, with his observation. If I'm Ripple, I'm pounding the table, arguing to the judge that before she even considers striking this defense, Ripple must be allowed full discovery on the matter. Absolutely. That makes logical sense to me. Now, here's another attorney. This will be the 4th one, actually, that I've cited in this piece that is not part of Ripple's team anyway. This is Jesse Hines. He wrote, here we go. Basically, the SEC is saying Ripple's fair notice defense and other defenses is/are not based in the law or fact. So the SEC is asking for a briefing schedule to strike these defenses. If these defenses are stricken, Ripple can't argue them at trial. Effectively, the SEC is saying, let's handle the battle over this due process/fair notice and this estoppel claim ASAP. Could the SEC win on its incoming motion to strike? Yes. Do I think they will? No. But I could very well be wrong here. And so, again, all of the attorneys that are publicly speaking about this that I've found to this point, except for one, Jake Chervinsky, all of them say that this is a legitimate claim here. And so at this point, I got to admit, based on what they persuaded me. It just seems unlikely that the judge is going to throw out these seemingly legitimate claims. I mean, and again, even without a legal background, just logically think through it. You're telling me that after 8 years, Ripple should have known that the whole period of that 8 years, mind you, while they were selling XRP, the whole period of it, they should have known that that they weren't allowed to do that, and that was a boo-boo. They should have known that, really? It doesn't pass the smell test. That's a piss-poor argument. Even if it's not legally a piss-poor argument, logically it is. And it really grinds my gears here. And then Jesse Hines wrote also, as a note to those who think this is all a show or part of the plan, this is the SEC firing shots that they're not here to play. And so I'm going to take a guess here that what Jesse Hines is citing here is like there's some fringe people in the community. It's a small percentage of the XRP community, and they're more on like the tinfoil hat type side of things, and they think that this is all some sort of weird structured thing, and there's no evidence to it. It's completely wacky. It's not how the real world operates. And so you do see comments like this. If you have Twitter and you scroll through it, you'll see people like, oh yeah, it's all just a show. It's part of the plan. It's the secret shadow people in power. No, shut up. Like, it does not make any damn sense. There's no evidence for that. It's nonsensical. And some people that just by nature, they're crafted in such a way by nature that they're more likely to just believe all sorts of stuff without evidence. By nature, I'm not crafted like that. If I'm going to believe something, you better provide me evidence. And the more extreme the claim, the more extreme the evidence required in order for me to believe it. And that's that. That's just how it is. And I'm not saying that there can't be weird things in life where, there are conspiracies. I'm not saying that, of course there can be. But just some people's natural tendency to just want to jump to that, it's just so irrational and so illogical. I cannot relate. And so I like to logically pick apart those types of comments when they pop up here. And I do that on this channel because we don't need the weird, wacky stuff out there to be thrilled and happy about what's happening with Ripple and XRP. And in terms of, not that we're thrilled about Ripple getting sued, of course not, I'm just saying, but in terms of XRP actually functionally being used and actually being adopted, we don't need all this wacky stuff. And there's all sorts of weird claims. I'm not going to get into the video. I'm probably already digressing too much. But anyway, I just want to share with you in this latest update here that the SEC, again, to sum it up, there being a bunch of baby back biatches, and the SEC is full of a bunch of asshats. And every other attorney I can find outside of Jake Chervinsky doesn't think that the SEC's claim here makes sense, including Ripple's very impressive legal defense team, including former high-up SEC employees. So just take that for what it's worth, but I'll wrap up there. I am not a financial advisor. Do not buy or sell anything because if anything I say or write, that would be a very, very, very bad idea. Until next time, to the moon, Lambo.